Friends, hello and welcome to another episode of The Legal Breakdown. I'm Jason Sansone at Sansone Howell Attorneys at Law, and I'm very honored to have with us a guest today, Aaron Budd. Aaron, thank you so much for joining us.
Yeah, thanks for having me, Jason.
We're very excited about it. Well, friends, we want to start off with just a couple tips and tricks. We will talk about some things that have come up on Aaron and I's radar, and then we're going to really jump into the substance of this episode. Aaron's going to talk about his main practice area, which is estate planning. We're going to talk about wills, trusts, advanced medical directives, the things you need to know or that you maybe should learn a little bit about today to take care of yourself and your loved ones in those later stages of life. But just a reminder for everyone, obviously, as we're getting rolling with our program, here we are in our third episode. We've got our first guest. We're very happy to have Aaron for that. You can call in at any time. The phone number is 405-347-7238. We would love to take your calls. That is live on the air. You can call us. In addition, you can watch us live on Facebook. If you're listening on the radio, it's KTLV 1220 AM. That is our main source for this show. But we simulcast on Facebook Live through the Sansone Howell webpage. And after the fact, if you didn't catch us live, you can always watch it on Facebook. You can watch it on YouTube. Or you can listen to this episode as a podcast. You can find our podcast on three main directories. Those are Spotify. You can find it on the Google Play app. And we're happy to be in the Apple iTunes directory. So any way you want to listen to this show, whether that's live, whether that's after the fact, definitely find us. And by all means, remember, you can call in. But now to dig in a little bit. Friends, life is tough. There is absolutely no reason for people to victimize you and make it even worse. And one of the things I think that frustrates Aaron and I, because I know his character is like mine, we want to help people. We got into this profession for all the right reasons. When people take advantage of you, when they scam you, it just makes me angry. And that's why we're going to keep talking about it. I've talked about it before. I've talked about it on my Facebook page before we had this program. We're going to talk about it again here today. Never stop or question yourself to be willing to question somebody. Always double check. Don't feel bad about that. If you get calls and you think they're collections and you're not sure, whoever they purport to be, whether that is one of these claiming to be a taxing agency like the Internal Revenue Service or the Oklahoma Tax Commission, whether that is someone claiming to be a creditor, it is perfectly fine to scrutinize that because, first off, legitimate creditors will make sure that you are comfortable. They're going to make sure that you pay through a legitimate means. Any red flag, such as you have to pay us by prepaid card or money order, that's not a legitimate debt. The silliest things, the ones that I'm going to talk about right here that I see, is they're making up case numbers for alleged lawsuits, but they're too sloppy to even use a system used in the state of Oklahoma. That's my favorite part, where you should immediately know it's a scam because it's not even possible to be a case number in our state. I have a client. The reason this has come to my attention today, and I want to bring it to the attention of all our viewers and listeners, I have a client who keeps getting calls. They're telling her she's being sued. The case number allegedly is, I'm only going to give part of it, but it's SD14 and then a bunch more numbers. Well, as Aaron knows, first off, SD is not a prefix. A civil lawsuit is going to be CJ, SC, CS, CV. There's no such thing as SD. You're not being sued with that. More importantly, there is absolutely, if that was a real case, that first 14 would be a 2014 lawsuit. It's doubtful you're just now being sued, but they're using a 2014 prefix number. So, we want to tell everybody out there, if you got a case number and it doesn't start with SC, CS, CJ, or CV, it's not real in this state. The next four numbers ought to be the year. So if it's not 2018 or 2019, you might want to question what's this thing? But always be willing to ask, be willing to look it up. You can check it out on OSCN or one of those. And We don't even mind helping people. If you call into our office and you just quickly say, does this sound real or not? I'll listen to you. I'll let you know if this is legitimate or not. But it's just unfortunate the things people are doing. The other thing I want to touch on real quick that I've seen a scam that unfortunately is far more sophisticated than what we just touched on, and that is hitting a lot of our bankruptcy debtors. And the problem is that these cases are public record. And so after someone has filed a bankruptcy, I can go and I can look up and see, oh, you owed money to certain real business. Let's say Tinker Federal Credit Union. That's a common one. But then they find a way to contact you, and they call you, and they say, hi, this is Tinker Federal Credit Union. You owe us money. It was not wiped out as part of your bankruptcy. You still have to pay us. We're calling to collect. Now, the problems are, first off, it very likely was discharged legitimately. That's not true, and you definitely wouldn't go about it that way. If there was a concern, you resolved it through the court. You don't just call up and say you owe us. And it's not someone legitimate like Tinker. So I'm going to be very clear out there to Tinker. This is not a derogatory statement on you. I'm just using you as an example because we've had this happen to our clients. But it was not related to legitimate business in any way. Those, unfortunately, are very good, sophisticated scams because they can talk the talk. They can say, you owe us $975. And when you know that was true at one point, folks, if you've got a bankruptcy attorney and you get a call like that, call your attorney. If I'm your attorney, call me. We will always verify whether that's real or not. We will gladly tell you if that's real or not. And the answer is almost always it's not. So, we've spent a little bit of time, first couple minutes of our episode, just addressing some of these scams because I really hate to see anybody fall victim to that. Now, moving over. This is Aaron Budd. Aaron is an attorney here in the Mid-Del area, as am I. And as we noted, he specializes in estate planning. Aaron, I already described it a little bit, but in your own words, how would you describe your practice? What would you say the things you do best or prefer to cater to the industry are?
So in terms of estate planning, one, I think that's a term that we learn in law school that we then try to explain to people. I do estate planning, and they don't really know what that means. But for me, it's helping prepare and protect what people spend a lifetime building and ensuring it goes to their kids, grandkids, loved ones, charities, wherever they want their money to go after they pass away in a way that either edifies the lives of loved ones or edifies the lives of others. If you're working your whole life to build up something, chances are you want it to go somewhere in a way that makes the world better after you're gone.
And so if I was a client or one of our callers was a client and we came to you and we wanted to do those things you just stated, we wanted to protect our legacy, we wanted to transition our assets to our loved ones, what would be some ways we would do that? What are your recommendations to an individual?
So there's a couple different ways. Generally when I'm talking to people, I'll tell them there's 3 real ways to transfer your assets, at least through when you pass away. There's intestate succession, which is really not doing anything. In fact, intestate means, in Latin, no plan, essentially. And that's where the state of Oklahoma's laws will step in and say where all your assets go. Another kind of plan is, it's called dying testate. That's dying with a will. And with a will, it's a letter of instructions to the court of where we want our assets to go. So it trumps or preempts Oklahoma's statutes on where your money goes, but Oklahoma statutes are still going to guide how that process works.
Sure. So obviously, similar to contract law, we can't do something unconscionable. We can't do something that violates the state law. So if I died and I had a wife and I had a will, Oklahoma state law won't let me leave nothing to my spouse, for example. Isn't that correct?
Unless she signs off on that.
But generally
speaking, yeah. The wife can force a share unless there's a prenuptial agreement or things like that. But postnuptial agreements are not valid in Oklahoma. So, but yeah, spouse can force a share, kids can force a share.
And so then we mentioned a third, I think. Did we? Maybe I apologize and cut you off with that. So we have intestacy for all of our listeners, which is when we die without a plan, without a will. Mm-hmm. We have with a will, or would that be trust for our third option?
And then, yeah, trust is going to be the third option. And that covers a lot of different kinds of plans that you can have. It's more of a category with multiple subcategories. But a trust is the third option. And main difference between a will and a trust is that when you pass away, the will only has power when you pass away. It's a document that tells the probate court where you want your money to go. That's actually one of the common misconceptions that I deal with is if you have a will, you don't avoid probate. And probate's a legal process designed to do for you what you can no longer do for yourself. If you're dead, you can't buy, sell, transfer assets. And so the court appoints someone to do that for you. Your will might indicate who you want that to be, but the court still has final determination of whether that person will be or will not be the person managing your affairs after you pass away. With a trust, what we're doing is removing assets from your name and transferring them into the name of the trust. And so we avoid probate because there's no assets in your name when you pass away. They're in your trust's name.
Ideally.
Ideally, yes. Unfortunately, there's still lots of probates where...
Yeah, we have to make sure that we put things in the trust, known as fund the trust. Mm-hmm. And so if over time you buy and sell and have a new home, and then you don't think to make sure that's deeded correctly, it might be outside your trust. Or if you have bank accounts, they might be outside the trust. And so we still have to have a spillover will just in case in those situations.
Yeah, absolutely. Another term for it's a pour over will.
Right.
But yeah, you still have to have a backup plan. Ideally, you're meeting with the attorney that helped you prepare the estate plan or another estate planning attorney somewhat regularly. And in terms of regularly for estate planning, that might be 2, 3, 4 years.
So, of course, state law is going to dictate some of these advantages and disadvantages, whether there's cost benefit, and states can vary greatly in that regard. But, of course, we're speaking only to Oklahoma and Oklahoma law. What would be some of our pros and cons? What would be an advantage versus disadvantage as we compare and contrast wills versus trusts?
Generally speaking, will is going to cost you less money to set up. And so there might be less upfront cost, and you don't have to worry about the process of funding your trust. Like with a will, I mean, your assets are your assets. They go where you have them go. If you have life insurance, that'll follow the beneficiary designation. IRAs, they're going to follow the beneficiary designation. And then everything else, it's up to the court process. And so it kind of eliminates to some extent your work in trying to put the plan together. But a con to that is that by you not doing it, your family likely doesn't know where you have bank accounts. Code to the safe. Where the key for the safety deposit box is, all these other things. So they don't know where your assets are, and it might take them weeks, months, maybe years to sort the whole process out. The trust, you're going to have a little bit more cost up front, but at the same time, you get privacy because probate is public record. You can go on OSCN.net, which you referenced earlier, ODCR, and you can pretty well access any probate file unless it's under seal. And if you can't access it online, you can go to the county court clerks and access the records that way.
So anonymity, you're going to have the advantage of, the size of your estate and your wealth may not become public record. You may be able to deal with that behind the curtains. But the downside, one of which we've just addressed, is that there usually is much more cost up front to establishing and creating the trust. But it can be much less expensive and much less lengthy than the probate process could stand to be tentatively.
Yeah, I mean, a common probate process can last 6 to 16 months.
Sure. Now, it is worth mentioning that Oklahoma does have a summary probate process, and that can be shorter and less expensive, but it's got limits on the type and size of assets you can have to use that summary probate process. So it's not nearly as frequently utilized, but it is available for some individuals who may have smaller amounts of means when they pass and still need those administered to their loved ones.
Yeah, and with that, there's dollar amounts that come into play with that. And so with those kind of probates, it can be done theoretically, at least by statute, in 45 days.
Sure.
It doesn't always work out that way just because probate dockets and judge availability. So it tends to be more like 50.
I do want to touch on, we've got one comment through social media, although I know that this particular individual is an attorney like ourselves and is most likely trolling us, but he's mentioned that another form of estate planning is joint tenancy, and I think we should address why that is an incredibly bad idea, although very commonly used by individuals in Oklahoma. What joint tenancy is it is one of the ways you can hold property. It is a type of deed. And so, for example, if you and your spouse spouse have a home, you would be tenants in common on, or joint tenants on that property, as opposed
you
to
might
joint
be tenants in common.
Not under Oklahoma state law, you cannot actually. If you own a house or buy it, you must be joint tenants if you're a married spouse. On the other hand, if we were not, we could have a tenancy in common just as an investment property or joint property. But joint tenancy is 100% undivided interest. So if me and my wife have the house, the right of survivorship survives. It transfers upon death. I do not have the power to sell my interest to it separate. It's not a divided, divisible amount. So as Aaron was just mentioning, if he and I go out and buy something, tenants in common means we could be 50-50 each. Mm-hmm. He could sell his portion. It would be apart from mine. If we were joint tenants, I have to sign off on his transfer. His transfer doesn't go to his estate. His transfer is not going to then, be something he could bequeath, have part of a will, or even become intestacy. The reason people use this as a roundabout means to attempting to do estate planning is that it is fundamentally simple. If you put your children on the deed to a house, when you pass, it would transfer to them. You would not need to have a probate. It would skip all of that. The problem with where this is painfully dangerous is, what if your children have their own financial woes? They have a credit card debt that turns into a judgment. That's now going to be a lien on your house. Yep. They file bankruptcy. It ends up in their bankruptcy estate. So you're commingling all of your affairs with other people, and sometimes that can be way too far in the future before you might even realize you need to be transferring or administering. So although it is entirely possible to use joint tenancy as a way to pass generation to generation, it almost never should be advised by a professional.
Well, and that also doesn't take into account the tax ramifications of doing that either.
Well, correct. Yes, it's not going to give you all the benefits of a transfer on death probate type situation. Mm-hmm. We've got another great question from our online, and we want to remind everyone, while we appreciate the questions through the social media commentary, please definitely keep those going. You can still call in with your live questions. So if you're on the air or listening to us over the air on KTLV 1220 AM, you may not be seeing these social media questions. You can absolutely call us at 405-347-7238. And I want Aaron to field this question, as he is our resident expert guest of the day. But I'm going to read aloud to everyone, what happens when you pass and you have outstanding bills like mortgages or credit cards? And that's exactly why, of course, we do have that probate process. But Aaron, take it away.
Well, I'd love to tell you that those bills don't have to be paid, but that is absolutely not the case. So whether you have a trust or a will, whether it's through probate or through trust administration outside of the court process, there is a process of when you pass away, we have to take an inventory or establish an inventory of assets.
But just to be very clear, they get paid by the estate, not by your heirs directly.
Not by children.
So your credit card debt isn't going to be, and no one else is responsible for that. Your kids don't have to pay your bills, but obviously they can't inherit anything. They don't get the benefit of your estate unless those bills are paid properly.
Yeah, money only goes to the kids after the expenses have been taken care of.
And that system is actually very similar to bankruptcy. We're going to have order of creditor priorities. We're going to have a time period of limits to submit those proof of claims. You can fight over how much they should be. Maybe you get them disallowed. But so the two examples here basically are, someone passes away. Every single thing they have in this world we're going to sell. We're going to liquidate. We're going to reduce to money. Let's say we come up with $100,000. If they have $150,000 in bills, then that remaining $50,000, it goes unpaid. No one has to be responsible for that. Your children will not be paying that. It doesn't fall on them. But it means that $100,000 doesn't end up in anyone else's hands. It goes to the creditors.
Yep.
On the other hand, you pass and you have $100,000 and you have $50,000 in bills. The $50,000 will be paid. The other $50,000 would be available based on however the will provides to administer, to distribute to your heirs.
Yeah. Well, there are things you can do to protect against that before the bills are created. I mean, you can't have an outstanding debt, transfer money, and avoid that bill. And that's something that if the attorney helps you do, then both you and the attorney could be in trouble. But if you created an irrevocable trust before that liability was created, you can transfer your assets in assets in that trust would be protected.
And this is another
theoretically, from
reason where
creditor claims.
trust can be superior under certain circumstances to a will, right? We were really addressing a probate situation, ignoring the concept of possibly having things already transferred as part of a trust, for example. I want to touch on something that I see, or at least we do encounter and we get calls about with a pretty high frequency, that any type of asset that's going to have legal title, a motor vehicle, a house, we really went into it, but more implied. It's going to take either a trust or an order of a court for that property to change hands. So if you are the only person on the deed to a house, there is no joint tenancy, and you pass, your children live there, they don't probate the estate, they don't notify the mortgage lender, they just keep making the payments. Folks, those payments are gifts. It's a mortgage lender's not going to transfer title into your name. You decide you want to sell that house. Who's going to sign off on the deed documents? Title company's never going to let you do it. You don't own it. You got to have a probate. I get calls quite regularly about, I've got a car, I can't figure out how to sell it. Well, your name isn't on it, so who decided you owned it? Only a court had the power to decide you own it. So either you can probate it or, Now, the other thing we didn't really touch on, I guess, there is really another way to estate planning, and that's quite simple as well. You can give your stuff away while you're still with us. And that's not a bad plan, depending on the size of your estate and what your intentions are.
And what asset is that you're giving away.
Absolutely. But, I'm sure you encounter, and we encounter with some frequency, I have a specific bequeath. I have a particular gift. I want this ring that was my grandfather's wedding band to be given to my grandson. Well, you can also just enjoy your own moment of getting to do that while you're both still alive. You don't have to wait until you're gone and then a will is read and have that ring found in a box on a nightstand and given to your grandson. You could give it to him. So just, something to keep in mind, unofficial. Nothing stops you from giving your stuff away at any point.
With financial assets, I would definitely talk to an attorney about that first, though, just because of tax ramifications.
Yeah, I'm speaking less to major financial assets and clearly much more in the sentimental, intrinsic items, non-monetary. But, going back to, especially because, we know that people run the full spectrum. We're not addressing this to the size of your wealth, and that how you decide to dictate your plans does matter.
Absolutely.
And so what we talked about, sometimes summary probate does make sense. Same with if, say you are renting, you don't even have, you don't own a home, the only asset remaining is the motor vehicle. It's not logical to probate an estate for a motor vehicle, in which scenario it might make sense to either sell the car if you're not able to drive or operate it anymore, if you're potentially infirm, or you could give it away if you trust the recipient that's receiving it.
And there's also transfer on death deeds that you can look into as well. Sure. Certainly with property.
And some of that circles back to where joint tenancy has some negative consequences, but possibilities.
Well, in transfer on death, you still get the positive step up in basis. And going back to the personal property that you were talking about, that's actually the place where most people get into fights after a loved one has passed. It's the grandfather's ring or dad's golf clubs, mom's brooch. There's only one, and multiple people want it. And so there is a lot of wisdom in planning that out, either by giving the asset away now or spelling out in writing where you want it to go.
We've used a good bit of our show, and really we've talked about assets, but what we haven't talked about, and it does encompass that big picture of your practice area of what we call estate planning. Of course, that's powers of attorney and advanced medical directives. Now, that's not the estate, but most people think of it similarly within that practice area.
Well, and they should be prepared along with an estate plan.
Absolutely. So tell us a little bit, what does that mean? How would you go about doing that? What are the benefits for an individual of a power of attorney and an advanced medical directive?
Well, any all-encompassing estate plan should include powers of attorney. If it's a will, like I said earlier, a will only has power when someone passes away. A trust can only cover and control the assets that are in the trust. And our bodies, IRAs, life insurance policies, filing joint tax returns even, are all actions that we take individually And so healthcare decisions can't be made through a trust. They have to be made through a healthcare power of attorney or the statutory durable power of attorney form. Financial decisions, same thing, either a separate power of attorney, durable power of attorney, or the statutory form. And those documents give authority to someone else to make decisions for you in the event that you're unable or unwilling to. Such as if I was in a car accident and was in a temporary induced coma, my wife, just by virtue of being married to me, does not have legal authority to make healthcare decisions for me. Even though we're married, even though there's legal documents proving that, there's no authority vested with her to make those decisions for me. And so even if the doctors wanted to go with what she said, she wouldn't have the power to do it.
And that brings up two great points that, again, I want to make sure we make explicitly clear for our viewers and our listeners. And number one, as Aaron mentioned, a will only begins upon passing. A power of attorney ends all authority on passing. So with quite high degree of frequency, people say, my loved one passed away, I have power of attorney. Well, that goes back to the fact that a court will appoint an executor of an estate, and they will be inclined to nominate who was ever nominated in the will, but they have discretion and authority to do otherwise. That power of attorney has no relevance anymore. The other point that's very critical is that when someone no longer has capacity, whether that is because they are suffering from dementia or Alzheimer's, or they have been in a terrible accident such as a motor vehicle wreck, it is too late to get a power of attorney. Then it's again, you're going to have to get an order of a court. You're going to have to do what's called a guardianship action so that the court can determine who will be the person in charge of this other person's affairs. And so we say that to stress that if you don't have a power of attorney, there's never a better time than now to get it taken care of, because a lot of times people wait too late and they call and they say, my loved one, my mother, my grandmother, she's in the nursing home. We think, things aren't going well. Can I come in and get a power of attorney? Well, can you bring her? No. If I come visit, can she articulate her wishes to me? Can we have a conversation? No, I can't legally execute or draft that power of attorney for you. And so I think that's a key thing for us to talk about.
Well, especially now as we're living longer, more people are spending a period of time, varying lengths of time, but it's majority of people are going to end up disabled before they pass away. And so having that power of attorney in place is really important, because once you can't make that decision, you can't sign the paperwork anymore. And it might be that the estate's pretty straightforward. You don't want to put together a will. You want to just go with joint tenancy, payable on death, transfer on death kind of a setup. But power of attorney, your only other option is guardianship. And that takes a while, and it's actually more expensive than just getting powers of attorney to begin with, frankly.
It's substantially more expensive, and it also does take a while. So good question also from online. What if someone is appointed as a power of attorney but doesn't want the responsibilities that come along with that? Do they have a choice? Well, yes, absolutely. They do not have to serve, and it's pretty standard form for attorneys when drafting a power of attorney to have foresight and nominate a couple successor power of attorneys, as well as maybe a catch-all like coming back onto the law firm to select if no one else is able to serve further. Because, going to our worst case scenarios, your wife is your power of attorney, but the two of you are in a tragic motor vehicle accident together. If you did not have a successor power of attorney named in that document, there would be no one able to serve as power of attorney. So we always are going to name multiple parties, and that can include that ability that if someone resigned or did not want to use that power. What if someone moves out of state? One of your children is serving in the military. They're not local. They're not available. You want to have some successor of power of attorneys named as well.
Yeah, I generally go for 3, maybe 4, just because that does give flexibility for life happening.
Absolutely. Yeah, one of the core things to look for when you are looking for an estate planning attorney, is that forward thinking that Aaron's already identified how he's great at looking at the chessboard, looking a few steps ahead. That's what we've got to do. Friends, we are out of time today. We got busy talking. Tune in next week. We're going to have another legislative update. We look forward to seeing you then. Have a good night.